Welcome back, everyone. We have an exciting afternoon planned for you. So by now, we're deep in the jungle of the American litigation system, but there's even more ground to map. It's not just businesses that have embraced globalization. The plaintiffs' lawyers have too. Litigation hotspots are popping up around the world, making businesses increasingly vulnerable to a wave of new lawsuits. Countries like Canada and Australia are fast approaching U.S. levels of class action litigation. And now, Europe is at the forefront of this new trend. Countries across the continent now have, or will soon have, their own class action laws. And the European Union is getting ready to unveil its own class action directive next year. If policymakers really want to know what's at stake, they can look no further than the recent case brought against MasterCard in London. It was a U.S. plaintiff's firm and a U.S. funder that brought the 14 billion, with a B, pound class action last year in a U.K. court. The case, to me, illustrates perfectly how the third-party litigation funding industry is exploding into a multi-billion-dollar global industry, as I also referenced earlier this morning. And in the MasterCard case, Gerchen Keller, the U.S. funder, initially invested 40 million pounds for the chance to make upwards in their contract of 1 billion pounds. The biggest funders are only getting bigger. Look at Burford Capital, which reported a 60% increase in income from litigation-related investments, or Bentham IMF, which reported a 109% increase in total income in 2016. So, the two ingredients for a global wave of lawsuits, laws allowing for class actions and the investors to fund them, are taking shape all too rapidly. The practice of third-party litigation funding is here to stay, so the real question is, can this practice and its most problematic parts be tamed? Our expert panel today has a lot to share with us, so I'm pleased to turn the panel over to Ken Daly of Sidley Austin in Brussels, who's going to kick it off. Ken, it's all yours. Thank you.
Thank you, Lisa. Good afternoon, everybody. I think we have just one slide to go up, and that is, well, I'm sure that'll come up in a moment. Our one slide just sets out very quickly the four topics that we're going to address today. The first one is, the five topics rather, the first one is forum shopping. The next is third-party litigation funding. Next, certification, the opt-in, opt-out mechanism, and finally, representative actions. So I want to maybe just say before we jump into those, just say that this is a bit of an experiment. This is a regulatory light model. It's a moderator-free panel. So we're going to sort of moderate ourselves and just hopefully do this as a conversation. But let me begin by talking a little about forum shopping in the European context. As Lisa mentioned, I'm from the Brussels. I practice in Brussels, where we've been witnessing the beginnings of a pretty significant forum shopping problem. In the EU, there's a very, very rapid and significant growth in the number of types of action that are available. Class actions in particular are now available in almost every member state, whereas only a few years ago, of the 28 member states, there really wasn't that much going on in terms of class actions. That's really changing. In all of the different member states where there are class actions, there are different rules in application. Some of the countries have opt-in, some have opt-out, some have contingency fees, some have very prominent third-party litigation funders present and participating. Some have certification mechanisms, some don't. Some really focus on the loser pays mechanism as a feature of their litigation, and others just don't. So as you can imagine, in that situation, the choice of your member state to pursue your litigation can be extremely significant. Now, that's regulated by something called the Brussels regulation. It's a piece of legislation that says that, in principle, you should always sue where the defendant is located, but then there's a very long list of exceptions. And the long list of exceptions mean, in practice, that there are all kinds of ways that people can choose which forum to litigate in. And so naturally, when they're making that choice, they are tending to go towards the jurisdictions where the barriers are the lowest, where they can use funding, where there is perhaps a contingency fee model, where there is, where there are fewer impediments to the type of litigation that they want to file. So it's really the beginning of a forum shopping, which I think, because we're a bit focused on solutions today, I think really only can be eradicated by some sort of common platform or better system to allocate between jurisdictions. But I know that one of the jurisdictions that lots of people are choosing is, of course, the Netherlands, and Dan here is from the Netherlands. Maybe you'd comment on why it is that people are going to the Netherlands.
Well, I keep asking that myself, to be truthfully. I think one of the reasons, except for the procedural rules that apply to our group litigation, as we call it, is that there is a sort of very internationally oriented bar, both on the defense side and on the claimant side. We have good judges. Even though our current system doesn't allow for monetary damages to be claimed on a collective basis, although that is about to change, it is still a mechanism that is widely used both in domestic cases and in cross-border cases, because as soon as liability is established on a collective level, these cases tend to either settle or you go forward in individual litigation, trying to sort of get the individuals on board. What we do see in terms of forum shopping is that one of the exceptions on your long list of exceptions on the Brussels regulation is generally used. For instance, if there's one defendant who is domiciled in the jurisdiction where the court is accessed, as long as there's a sufficient link between the claim against that defendant, you can sue also the other defendants over which the court would otherwise have no jurisdiction. And that leads, in a number of cases, for instance, in the area of cartel damages follow-on claims, but also securities claims, that you will find defendants from Brazil, from Asian countries to have to defend themselves in our jurisdiction.
And Stuart?
Well, we don't have a real problem with forum shopping within Australia, because where we have class actions, the rules and procedure are the same and the courts are fairly uniform. The problem for us, or perhaps as a lawyer as the benefit, is we're going to start seeing, we believe, inbound forum shoppers, because we have a very liberal system. No certification, no predominance of common issues over individual issues. And when you have a very plaintiff-friendly class action system, perhaps in some respects more plaintiff-friendly than the US, we are concerned that we're going to have people coming in to try and take advantage of that, and our court has indicated that in certain circumstances it will take jurisdiction.
And is forum shopping a feature of Canadian litigation?
Yeah, I mean, we certainly have seen the inbound class actions that Stuart is talking about. Most recently, we've seen a claim brought by people injured in the Rana Plaza collapse in Bangladesh in 2013. Our court said that it would take jurisdiction. Fortunately, went on to say there was no tort duty in that case and dismissed it. We've also seen in the securities context, class members from outside the country suing an Ontario company that was traded on the New York Exchange because the disclosure document that was the basis for the suit was issued in Ontario. The court said it had primary jurisdiction simpliciter, went on to stay the case by the foreign entities on the basis that of foreign convenience, but then later when the US case that was ongoing was dismissed, they lifted the stay so that the foreign claimants could get back into the class action. So forum conveniens is kind of the way to deal with that. In terms of within the country itself, forum shopping really isn't the issue among the provinces. The issue is overlapping class actions, because typically we'll see not one, but 3 or 4 or 5 class actions across the country. And the issue is, how do you manage those cases? We don't have an MDL process. Our federal government and federal court can't deal with provincial overlapping class actions because of our constitution. The courts in most of the provinces have been doing a better job at trying to deal with that and work together, although it's ad hoc. There's statutes in a few provinces. There could be more. In Quebec, they've kind of gone the opposite direction. In Quebec, they have enacted a statute that says the court cannot stay a Quebec class action solely on the grounds that the Quebec class members are members of a class in another province. So we're trying to deal with that. The CBA, the Canadian Bar Association, has recently issued a draft protocol to help judges learn about the cases in other jurisdictions, learn about stay motions, certification motions, coordinate and communicate among themselves, and that's something that, for people who don't know about it, you should be taking a look at. There's opportunity to make submissions on the CBA draft protocol.
If I may just weigh in on that, I think that one of the challenges for Europe going forward is exactly this, that if you don't put in place some mechanism of dealing with parallel class actions in various member states, you're in deep trouble. And not only as a defendant, but also as a judiciary, because you really need to be able to deal with a case because it's in front of you and you need to sort of adjudicate it.
Incidentally, I should mention that there's some materials on forum shopping on the some ILR publications on this on the table outside. I guess one of the big push and pull factors in any forum shopping issue is going to be how actions are funded.
So Australia has done some wonderful things for humanity. We gave the world penicillin, Wi-Fi, and the litigation funding industry. That's now spread around the world. In Australia, funders are now initiating and driving class actions. They're actually the people going out and looking for them. About 50% of all Australian class actions are funded by litigation funders. And the funders are now looking to work with corporations, major corporations, in funding commercial litigation. Now, the ILR has been doing a great job. It has been campaigning in Australia, working with the business community to find some solutions to the worst excesses of the industry, some of the problems which we see all around the world. But as I said, this industry has spread across the globe. Ken, are you seeing litigation funding in Europe?
Absolutely, it's become a really significant feature of litigation in Europe. I should maybe emphasize one thing, which is that it's operating slightly differently to the way that litigation funding operates here in the US. Here in the US, you have lawyers with contingency fees, and they agree to share part of their contingency fee with a funder. Europe typically doesn't have contingency fees. Instead, lawyers will work on some different basis, on an hourly basis. So it's really the funders who are operating on the contingency fee basis, and they are the ones typically who are taking the place that you typically find the role typically played by the plaintiff's firm here in the US. It's really the funders in Europe who are instigating, conceiving of, and driving the litigation. And so thinking about, what can or should be done about that, it's interesting to compare the two models, the way that lawyers operate and the way that funders operate. If you think from the starting point that both are operating on a contingency fee basis, lawyers, at least in Europe, are subject to bar regulation. They disclose their participation in a case. They're subject to fiduciary duties towards their clients. And there's a whole host of regulatory and other restraints on their ability to act. Funders, on the other hand, at least in Europe, are subject to exactly no regulation at all. There's no member state in the EU that has any rules dictating how funders may participate in cases.
And indeed in Australia, there's no, lawyers are not allowed to take a contingency. So we see the same thing happening when they're with the funders. We have minimal regulation. It is essentially an unregulated industry. But Canada?
So we have seen very much an increase in third-party litigation funders and funding in class actions. There's no statutory regulation of it at this stage. It's rather ad hoc among the judges. We have some provinces Typically, the funders are going to the court to ask for approval in advance of the agreement with the plaintiff and their counsel to protect themselves, I assume. And in some provinces, they're allowing that to happen without notice to the defendants. In Ontario, where I practice primarily, the judges that have waded into this have typically wanted to have disclosure to the defendant. They want approval by the court. They're concerned about many of the things that we're concerned about. Is the compensation to the funder appropriate? Does it overcompensate the funder? Is the funder controlling the litigation, very importantly? Is the funding needed for access to justice, importantly? And in a couple of cases, they've altered the funding agreement. For example, in one recently, they reduced the funder's potential fee to 10%. It was something in the neighborhood of 18 to 25%, I believe. Keep in mind, in our jurisdiction, contingency fees are allowed, and so the contingency fee would have been on top of the funder's fee. I think the total was potentially 38% in that particular case. So the court said that the funder could only have a 10% fee for now, left open the possibility they'd approve a higher fee later, and also required the funder to post security for costs because we have a loser pays cost system, and they want the defendant to be able to recover the costs from the party that's really driving the litigation.
And Dan, are you seeing in the Netherlands third-party litigation funding?
Yeah, we see it. We also see funders actively sort of marketing themselves. I got a call the other day from one of the funders that was mentioned by Lisa, and I said, well, I'm a defense lawyer, what do you want with me? Yes, well, that's interesting for your business clients because they have claims and they have unused assets on their balance sheet and they might want to capitalize on that, they otherwise would not. The irony as to no regulation is that to the extent that there is third-party litigation funding for a class action on behalf of consumers, is that of course the EU consumer protection laws might kick in. And although I'm on the defense side, I would love to do a claimant's case on behalf of the consumers for unfair terms imposed on them by some funder if that should ever arise. But I think I would be in favor of regulation because I've dealt with a specific case where the consumers who had actually signed up had no way of but following the decision of the funders and the lawyers as to whether to settle or not. And that might have been detrimental to them in the specific circumstances.
One of the issues we've talked about is disclosure, and there's an argument that disclosure should come as part of the certification process. Gord, certification in Canada? I think you're the expert on the subject.
We wanted to talk about certification standards. Generally, they vary, obviously, around the globe. Australia, I've heard from Stuart, really has virtually no certification threshold. The U.S., as we all know, has a fairly defined, detailed set of criteria and a fairly high evidentiary burden on the plaintiff in terms of those criteria. Canada is a watered-down set of criteria with a fairly low evidentiary burden. So we want to talk a little bit about what companies might universally think would be appropriate, warranted criteria for certification around the globe. I'll start with the requirement for common issues in the claims of class members that would be significantly advanced by the class action. It seems that has to be the starting point, and without that, there's no efficiency, there's no cost savings, there's no increased access to justice. That is one of the key battlegrounds in Canada for class certification. Stuart, I think what you said is you don't have it at all. When is that assessed? Does it ever get assessed, and should it be assessed earlier in Australia?
Well, at the moment in Australia there is a law reform commission in one state looking at this issue, and there has been a bitterly fought debate between the funders, the plaintiffs' lawyers on the one hand, opposed to certification, and the defence lawyers and business generally in favour of certification. The problem is that not only do we not have certification, we don't have a requirement of commonality, or we don't have a requirement of the common issues predominating over the individual. So provided you can find one single issue of common fact or law, which you always can, you run a class action. So in Australia we can run a class action to judgment on a claim involving a pharmaceutical or a medical device. which is just crazy. So we would like to see, firstly, certification, dealing in the context of litigation funding with some of the issues like disclosure and setting the percentage of the contingency. We'd also like to see a tightening of the rules to require more of a predominance of common issues over individual, to try and reduce the number of very, very broad class actions.
So one of the other criteria that have been talked about periodically is the merits assessment. And this can be anything from a pleadings assessment, which I think is what we primarily have in Canada and the US now, whether there's a sustainable cause of action pleaded, to some sort of evidentiary hearing. When the Law Reform Commission in Ontario in 1982 originally looked at class actions, they recommended a merits test be part of, an evidentiary merits test be part of the certification standards to try and avoid or reduce the risk of meritless claims being brought designed to pressure defendants into settlements regardless of the lack of merit in the case. The Ontario government of the day did not accept that. They didn't put in a merits test. They did retain our loser pays cost rule, which helps to some degree, although with funders that's a little bit taken away. But when they enacted securities, the secondary market securities class actions some years ago, they imposed a leave test, and the leave test requires the plaintiff to show both good faith in the bringing of the class action, but also a real possibility of success. And that's an evidentiary hearing before the class action even goes to a certification hearing. That has met with I think, some success. Defendants have challenged the merits and gotten the cases dismissed. I think where defendants thought that it wasn't worthwhile to challenge the merits, they didn't oppose the leave and went on to fight certification. But that's something that in the ILR publication, it's on the table and released with respect to reform in Canada, has been recommended be expanded to all of the class actions for the same reason it was in the secondary market cases, to discourage blackmail strike suits, essentially. Stuart, what about that? We have perhaps we're in a bit of a unique place because you and I try class actions because they get past our certification threshold so easily, and we get to the merits then. What about getting to the merits earlier? Is there a pleadings assessment? Is there?
We do have well, in theory, we have a strict system of pleading. Unfortunately, the courts are not always aggressive in enforcing the proper pleading of cases. And then what we find is if a case is properly pleaded, it reduces the amount of time, it reduces the cost of running the action. If the case is left as an amorphous mess with no properly pleaded case, then it becomes much, much more difficult. So one of the things that we do in Australia is we try and knock out class actions or statements of claim which are not properly pleaded. And in one famous tobacco class action, I think we went through 7 attempts by the plaintiffs to properly plead the case. Well, they couldn't, and finally the judge threw it out. Unfortunately, that's fairly rare. We wish we saw more of it.
Can Europe, common issues and merits, any assessment in the certification stage?
Well, as I was mentioning earlier, the principal feature of Europe is that there is no common system. So you have a different answer to that question in each one of the 28 different member states of the EU. What the European Commission has tried to do has issued a recommendation to all of the member states, setting out what it believes class action systems should look like. And one of its suggestions in that was that every member state with a class action system should put in place an early assessment of the merits and an early assessment of common issues so that bad claims can be knocked out early. Now, the degree to which member states have actually followed that is very uneven. Some have, some haven't. The UK has rushed ahead with an opt-out class action system, but it does have an early certification mechanism, and indeed that was the way in which that MasterCard case that Lisa mentioned, has for the moment been held in abeyance because it failed at certification.
So, Stuart, maybe this is for you. We hear plaintiffs say, well, if you have a certification threshold, it's difficult, it defeats access to justice, it's more expensive, it just results in delay. How do we respond to that on the defense side and for businesses?
I think we talk about efficiency, I think we talk about cost saving. But the problem we face in Australia is that the plaintiffs' lawyers assert that in the United States it is overly expensive now and it's overly complex. But as we heard this morning, part of that is because cases are effectively either resolved at certification or move on to settlement. In Australia, we actually get to try some class actions, and I'm pleased to say the defence not uncommonly wins. So there is that slightly different dynamic.
And one of the things that we've been teeing off of is a couple of statements from our Supreme Court that say that access to justice doesn't mean you're entitled to bring frivolous claims. And in fact, if you have a system that encourages frivolous claims, you will take away access to justice and efficiency for the system overall. And the second thing we rely on is a statement that there is access to justice entitlement for both the plaintiff and the defense side. And when we talk about justice, it's not just about can you get into the courtroom, but can you get a just outcome. If we have cases that are brought that are meritless but are forcing defendants to settle for other reasons, those aren't just results. And so we can rely on that to say we need a balanced and fair process. We've heard before there will be appropriate cases for class actions. They're not going away, but we do need to make sure that we've got a balanced and fair process to both sides in that process. Ken, we want to talk about opt-out and opt-in in terms of balance, and how does that fit?
The opt-in, opt-out debate in Europe has been, has been really intense. Again, in this recommendation that I mentioned, the European Commission has very strongly favoured an opt-in mechanism. It proposed that all member states should avoid opt-out. The thinking behind that being that opt-out is probably the single characteristic of the US system that Europeans are said not to like. But having said that, there are already a number of opt-out mechanisms in Europe. So you can see there that the Commission's recommendation is not being followed slavishly, if indeed at all. There are opt-out mechanisms. There's one in the UK, as I mentioned a moment ago. There's one in the Netherlands, and there are others in Poland and some other member states, and there are more on the way. But thinking about what that means, and maybe tying it in a little bit to our earlier conversation about funding, when you have a combination of funded opt-out mechanisms, you're really dealing with something that is potentially problematic. You're dealing with, again, an unregulated funder. You're dealing with a very diffuse class of individuals who may or may not know that they are even being represented, not this time by a lawyer, but in effect are being represented by a funder that they perhaps have never heard of. And I think that the potential problems can be best illustrated by what happened in the MasterCard case that Lisa mentioned. When at the certification phase, I mentioned it got put to one side. It isn't completely dead yet. There's an appeal pending. But in that context, the agreement that the funders had put in place was disclosed, and it became apparent that the funders had put in place a mechanism that gave them vastly greater returns if there was a large undistributed award. So the more that did not reach consumers, the higher percentage they got. So in circumstances where really the lawyers are working for the funders, and they have the strongest possible incentive not to find the people to actually give the money to, you can see that you really are in uncharted territory and dangerous territory there.
So in Australia, we started with opt-out. That was what the Parliament legislated. That's what the Commission originally recommended. That didn't work for litigation funders because they needed to have class actions where people had signed up to agree to give up to 40%, sometimes more, of the verdict or the settlement to the funder. So the system got perverted and we became an opt-in system. Now the litigation funders have invented something called the common fund. The theory is that nobody should get a free ride, that the funders should fund a small number of plaintiffs. It should be an opt-out class action, so everybody comes in regardless of whether they know they're in the case. And if the case is successful, you get a common fund order which says, guess what? The funder gets 40%, 30% or whatever of everybody's judgment, notwithstanding the fact they never signed up to it, notwithstanding the fact they didn't know about it, to be fair. the worst possible arrangement of all. And now we're moving back as a result of that to an opt-out system.
If I just may make one comment, I think the debate on opt-in and opt-out is difficult because for defendants, their preference might be influenced by the stage a case is in. I mean, once you want to sit down and talk settlement, you rather want to know what your tail risk is, because otherwise, if you don't have any mechanism to know who else is out there, which you have with an opt-in system, you are just putting a floor in place on which others then can build a new claim. So I think we need to find something that takes us beyond the sort of binary opposition of opt-in and opt-out to get something that really works and is fair and balanced for all parties concerned.
There's no doubt about it that if you have a settlement in an opt-out system, you can extinguish the tail, you can get certainty, you can get rapid closure, and you can manage your overall exposure. So from a business perspective, sometimes opt-out has real advantages.
And the disadvantage I think we've seen is that companies can end up paying more than they would be obliged to if it was an opt-in system. We've seen a couple of cases in Canada where an amount was set aside for a fund for settlement purposes on the assumption that a certain number of people would get through the gates or the entitlement criteria. In other words, be able to show that they had the injury at issue. And then when it actually went through the settlement process, much fewer actually got through the gates, and one could argue that both the amount that the defendant paid was overcompensation, but also the amount that the plaintiff gets, which is a percentage of what the defendant pays, was higher than it should be. Those are the balancing that has part of the balancing.
Which emphasises the importance of a regulatory system which delivers fairness to both sides.
Yeah, closely connected to the question of whether something is opt-in, opt-out can be the question of who's really in charge of the litigation. And in Europe, there's an increasing use of what are called representative actions, where you have these public entities that are responsible for having carriage of the case down. I know that's a big feature in the Netherlands.
Yeah, well, the way it works in my jurisdiction is that there is not a member of the class who is sort of the leading the class, but there is a foundation or an association which is deemed to have no profit objective that brings the claim. That can be a long-standing organization such as the shareholders, the private shareholders investors association or a consumer association, or it can be an ad hoc foundation formed specifically to manage a case if something happens. The problem also here is that this system was devised 20 years ago because Parliament didn't want entrepreneurial lawyering. But what happens instead is that the lawyers tend to get paid by the hour, and the guys behind it, they strike the contingency fees, just as you said. And that even happened before the appearance of litigation funders. There are other systems that use an ombudsman, or that use a limited list of non-government organizations, but with a license from the government to act as a class action representative body. Well, we have to wait and see what the Commission will bring in next year's plans as to how they want to deal with that. I think every form has its pros and its cons. What national governments tend to overlook is that in many countries the king can do wrong, so the government can be sued. And at least in my jurisdiction, the national government, but also local governments, are quite often also sued in class action litigation. So that also brings about many interesting questions as to whether then a government-appointed organization is able to bring those claims, where there's not a conflict of interest there.
In Canada, we generally have a class member who, as opposed to an organization, bringing the claims, and they have to, as part of the certification test, they have to show that they're going to fairly and adequately represent the interests of the class, and that they don't have a conflict of interest with the class, at least on the common issues, which will be the first stage of the trial process. In Quebec, however, they do allow organizations to bring class actions. They have to designate one of their members who is a class member, and that person will be assessed on their adequacy. But there's an organization called Option Consommateurs. I'm sure I've mispronounced that. But they are frequently a plaintiff in class actions. One of the issues around the organization as the plaintiff is this whole idea of conflict of interest. Do they have a political agenda, for example, that is going to override the interest in getting compensation or fair compensation to the class members? If they're funded by a third-party funder, how does that work? Is it then really the funder who's controlling the litigation, which is one of the concerns that certainly in Ontario they've considered? How do you look at the adequacy of a representative plaintiff in Australia, or do you look at that at all?
We don't. Because there's no certification, there's no real mechanism to look at it. Essentially, either the plaintiff's lawyer, if it's on a case being run by the lawyer on a normal fee basis, or the litigation funder will choose who the representative plaintiff is, and the people behind the case will actually control it. We do have the potential for government agencies to bring class actions, but it's only ever been done once or twice, and that was a long time ago.
We only have a couple of minutes left, but we've touched in this discussion on a number of the different problems and a number of the different types of safeguards that might be put in place to stop the litigation problems in all of our jurisdictions. I wonder, in the time remaining, could we each just think of maybe one safeguard, either from your own jurisdiction that you think should be exported, or a safeguard that you've heard of in another jurisdiction that you'd like to import to your own, and whether we could each sort of pick our one favorite safeguard. Maybe Dan, start with you.
Well, I think that for jurisdictions that do not have a first step in the process that sort of serves as a certain threshold, call it certification or whatever, I think you need to have that. We heard this morning that if it ends there, that has its own problems, but there are many jurisdictions out there who are not even there yet. So yes, we need to learn from the US experience as to how to deal if it would develop into that practice. So we need to figure out how to deal with that. But to having some form of threshold supervision would be okay. And something else that I would recommend is that it is not all left to the parties settling how the distribution mechanism and how the incentives for the funders and the plaintiffs' lawyers to be paid out of whatever is distributed, that there is some form of oversight. And speaking for Europe, I would advocate that we have some sort of standard set of principles governing that, because otherwise you would keep forum shopping, and we need to have some form of level playing field, because going back to your Brussels regulation, one of the main purposes of that is that it is for defendants. It is that you know where you can expect to be sued. And as long as for class action litigation we have this sort of free-for-all, that objective is certainly not being served.
For me, a certification process along the lines that is running in parts of Canada, which Gord has described. But you know what I'd like most of all in Australia, and that is a business community and a group of organisations like ILR or European Justice Forum who actually come out and campaign for reform. One of the problems we have in Australia is that there is not this organisation that you have in Europe, that you have here in the United States. And I guess the message I'd be trying to deliver to anybody that's here that has subsidiaries in Australia is to encourage them to start to work for reform, because we look at, from Australia, we look at what you've achieved in the US particularly, and we go, gee, we've got to do that too. So if there's any message that comes out of this from the Australian perspective, please encourage your subs to support proper reform.
In our jurisdiction, I would say the loser pays cost system. It's not the answer to everything, but we need to maintain it. We need to make sure that the people who are driving the litigation are on the hook for it, because at the moment the representative plaintiff is the only person on the hook for the loser pays costs, and typically they're not going to have the kind of resources that would allow a defendant to recover their loser pays costs. We have a partial indemnity system. It's not a full indemnity system, but it still can be in the neighborhood of 25 to 50% of your actual legal fees, and that's not just disbursements, but the lawyer's time if you're successful. But if you have nobody to collect it from, it's not that useful. If the third-party funders are going to be encouraging this kind of litigation, they should be on the hook for that if the cases are lost, so at least they have an incentive to give some consideration to the merits in the case before they push it forward. Like Stuart, in terms of advocacy on these issues, the Ontario Law Commission has recently, Law Commission of Ontario, pardon me, has recently reinvigorated a project to look at the experience with class actions in Ontario and to consider the possibility of reforms. They're starting their consultation process at the end of this year with the plan to publish a report by the end of next year. I would encourage defendants to get engaged on that, businesses that may be defendants in class actions, and I'd be happy to talk to anybody about that at any time.
Well, I guess it's so hard to choose between all of these safeguards because I do sort of want them all. And it's particularly important in Europe because our system... Well, why not? But it's important in Europe because our system is very much under construction. As was mentioned earlier, the European Commission is about to come out with a piece of legislation which will now impose a kind of federal type of class action across the EU. The features of that are as yet unknown, but it's going to be a very hot topic in Europe for the next 6 to 12 months. But I suppose if I had to pick one safeguard, for me it would have to focus on the funders. I mean, I think if you follow the money, I think that really has been the biggest problem here in the US. The possibility to pursue frivolous claims for profit has been the root of all of the evil in the system. And I think in Europe, where we have a system with no registration, no identification even of the funders, no transparency of when they're even involved in a case, no cap on the amounts that they can retrieve, no ethical duty, really no limitations at all on the way that they can initiate and pursue cases. For me, that's the biggest problem coming down the pipeline in Europe. But like I say, I'd like them all. But with that, I think we are out of time. So thank you, gentlemen. Thank you all.
Thank you.